Hello, I'm Matthew Joseph, and I'm going to talk about what happens if you overstay your status in the United States. First, some basics. Everyone who enters the United States must be inspected by an immigration officer at the border or at the airport. Anyone who enters without inspection, which is called EWI or EWI, is unlawfully present in the United States and can be deported. When you enter the United States, you fill out a white card called an I-94, which is then marked and stamped by the immigration officer. The I-94 card is the document that determines your status in the United States. For example, visitor, worker, or student. It also indicates how long you are allowed to remain in the United States. In general, you must either leave the United States or get permission from the Department of Homeland Security to stay longer before the date on your I-94 card passes. If you fail to take one of these actions, you are considered to be unlawfully present in the United States and can be placed into deportation proceedings. If you ask the Department of Homeland Security to allow you to stay longer in the United States than the date on your I-94 card, you are allowed to stay for 120 days past the date on your I-94 if you make your application to the department before that date expires. But be careful. If the Department of Homeland Security decides it will not give you permission to stay longer, you should leave the United States as soon as possible. Otherwise, you will be unlawfully present and can be deported. If you're unlawfully present in the United States for more than 180 days, but less than 1 year, and you leave before being placed into deportation proceedings, you will not be able to return to the United States for 3 years after you leave. If you are unlawfully present for 1 year or more before you leave voluntarily or are deported, you will not be able to come back for 10 years after you leave. If you are in the United States, you are allowed to adjust status, which means apply for a green card, in an employment-based category, even if you have been out of status or worked without permission for less than 180 days, as long as you meet all other requirements for the green card. This rule does not apply to family-based green cards. If you are unlawfully present in the United States and are placed into deportation proceedings, you may be able to avoid deportation. One way to do this is to apply for cancellation of removal. To qualify for cancellation of removal, you have to meet several requirements. First, you must have been in the United States continuously for 10 years. Second, you must be a person of good moral character. You must not have been convicted of certain types of crimes. Finally, you have to establish that your spouse, parent, or child, who must be a lawful permanent resident, or a U.S. citizen, would suffer exceptional and extremely unusual hardship if you are deported. If you are placed into deportation proceedings, you have the right to have an attorney represent you. Because deportation can be complicated, especially if you try to apply for cancellation of removal, you should consult an attorney. If you cannot find an attorney to represent you before your first hearing in front of the immigration judge, you should ask the judge to give you more time to find an attorney before the proceedings continue. If you have more questions about unlawful presence in the United States, please consult an immigration attorney. Thank you.